Hello, everyone. My name's Michael Feeney. I'm a barrister at Francis Taylor Building, specializing in planning law. And today I'm going to be talking about planning appeals, getting it right from start to finish. So, in terms of what we're going to cover in the seminar today, it should be roughly 45 minutes. Overview of the appeal process from the start to finish. That will include choosing the right appeal format, what makes a good statement of case, statements of common ground, how to use them effectively, and then, very importantly, preparing proofs of evidence, rebuttal evidence, how to prepare as a witness, including how to actually give evidence in examination in chief, cross-examination, and re-examination, costs applications, what the test is, when to apply, how to respond, and then finally, tips for effective closing submission. So that's what we're going to cover today. And I think you'll get the slides at the end of the talk as well. And I think there's a very short multiple choice Q&A at the end as well for you to complete. So in terms of the appeal format, when a planning appeal is submitted, there are three options for the planning inspectorate: written reps, hearing, or inquiry. Ultimately, it's PINS that decides the procedure, but parties' views are taken into account. So when an appellant submits an appeal, they have to address the PINS procedure determination criteria. Those criteria are set out in the PINS procedural guide, which is available online. So it's obviously important to address those as an appellant when you're submitting the appeal. It's important to note that there were certain changes made, in particular to the written reps procedure recently. So different procedural guides apply depending on whether the application in question was made before or after the 1st of April 2026. So important to make sure that you're looking at the correct PINS procedural guide. So running through the different formats very quickly, what the main differences are. Written reps, as the name suggests, it's decided on the papers, with the inspector usually making a site visit, which is unaccompanied in most cases. Now, the default position for any application submitted after the 1st of April this year, and this is very important, is that there's no opportunity for the appellant to submit any evidence that's not already before the local planning authority. So after the 1st of April, for applications submitted after the 1st of April this year, the default position is that on a written reps appeal, the appellant can only rely effectively on what was before the LPA. There's no chance to fix anything. There's no chance to introduce any new evidence.